All right, hello, welcome everybody to the ninth discussion seminar of Economics 12, Principles of Economics 2. Today, I'm delighted to have as our guest discussant Stefan Kinsella, whose paper we had covered during the lecture on Monday and who's written extensively on intellectual property and on the intellectual justification for intellectual property. During the discussion on Monday, the lecture focused on the earlier parts of Stefan's paper, which pertained to the concept of ownership and property and the justifications for property, why property emerges, why property is legitimate. And then toward the end of the paper, why property is legitimate, and then why intellectual property doesn't really make sense. And we said, ultimately, the problem is the issue of scarcity. When things are scarce, or scarce, then property is the way that we get over this scarcity. Property is the way that we deal. Property is how we deal with it, how we are able to manage scarce resources. But with ideas, given that they're not scarce, ultimately you cannot enforce property rights in them. There is no need for enforcement of property rights in them, and the only way that you can actually enforce it would have to involve, as we ended last time, it'd have to involve some kind of control over the body and the property of another person. In other words, you buy my book, and in order for me to enforce intellectual property on the content of the book, I have to control your body, what you can do with your property. I have to have some mechanism for preventing you from taking something that you own, which is, say, my book, a copy of my book, and photocopying it and giving it to your friend, or scanning it and putting it online and emailing it to all your friends. There's no way of doing that without violating your body and your property. And so this, I think, for me, is the kill shot of the intellectual property argument. However, this isn't the only kill shot that we have. We have plenty of others. Generally, the argument for patents is built from a utilitarian perspective, which is the idea that, okay, maybe it's not nice that we have to throw the occasional teenager in jail for downloading an Iron Maiden song, but to make an omelet, you have to break some eggs. And we throw the occasional teenager in jail, but then that just ends up giving more incentive for rock and roll bands to produce better music, because then they know that their intellectual property is protected. There's a lot to discuss in this and a lot of work on empirical stuff, which I thought would be a good discussion to have today. And I'd like to see what Stefan has to say, and I hope you guys are looking forward to this as much as I am. Stefan, the floor is yours.
Thank you, Dr. Amous. I appreciate this. I'm always happy to talk about liberty and IP and things that I've figured out a little bit about over the years. There were a couple of questions from some students from previous lectures, and I'm happy to address them with you whenever you want to. But if you want me to speak a little while on the utilitarian aspect, so in my Against Intellectual Property article, I did talk about the scarcity issue and the functions of property rights in general, and why the basic case for IP is incoherent, which I believe Dr. Amous has already covered. And the fundamental reason is that information is always a property or a characteristic or a feature of an underlying owned resource, because it's just the arrangement of some previous good, and those previous goods already have owners. And so the only way to have property rights in information is to basically make it what Roger Long calls a universal, which means if I have a red ball and I own the ball, and that means that I own the features or the properties of that ball, that I own its redness, and that means I own everyone else's red thing in the world, or every red ball, which would obviously be absurd. It would be a way of taking property from them. So that's the basic case, the principal proprietarian case against IP. The thing is, the advocates of IP, which is heavily entrenched in today's society, in fact, I believe that it's one of the most insidious ideas that informs lots of our legal systems and practices. The trade war with China, Trump's idea, all the accusations that China is stealing our IP, and they're never clear about that. So this idea of intellectual property has risen its head in a kind of a herky-jerky way ever since Locke had his argument for private property rights, which relied upon this idea that you own yourself, which is metaphorical and vague, and therefore you own your labor, which is vague, and therefore you own what you mix your labor with. So then you get to this idea that you own your labor, which from an Austrian or economic perspective is just action. So saying you own your action is a weird thing to say. Action is what you do using the resources that you own or that you have possession of, like your body and other scarce things. So saying that you own your body and yourself and your labor and you own whatever you create that has value is all a big confusion. This is what the Ayn Rand types do when they talk about owning values, even though we Austrians believe that value is something that you just demonstrate that you're acting towards. You demonstrate that you value something by acting toward to achieve it. So there's a lot of confusion in the original Lockean idea and what it's led to. Now, this led to the practice in the continent in Europe hundreds of years ago of censorship of books, starting with the threat that the Gutenberg press posed to the established order and to the grant of monopolies. But they were called monopoly privileges originally, right? Patents were called monopoly privilege grants, and copyright was seen as censorship. With the advent of the U.S. Constitution and the dawn of the Industrial Revolution, so the U.S. Constitution authorized Congress to enact patent and copyright law, but basically for utilitarian reasons, like to promote invention, to reward the creator. And it was only for a limited time because the idea was that this is a deviation from the natural order. We understand this is not the common law. This is not the normal private property rights. It does represent an intrusion of private property rights, but we're going to allow it for a temporary time to try to fix the situation. So there was always a utilitarian mentality behind it. But of course, the framers were just going with tradition from England and from European practice. They had no empirical evidence. There was no econometric science back then. So it was just a hunch or a guess that the government could come in and give some kind of benefit, some monopoly privilege to some producers, namely authors and painters and novelists and inventors, to induce them to produce output. So that's the basic argument. But you would think that in the 200 years since then, right, since the dawn of the Industrial Revolution around 1800 to now, we would have had studies that can at least start proving empirically their claims that the patent system and the copyright system does make us all better off by producing an excess of innovation. So my view is this, that most proponents of intellectual property, so what happened was, by the way, as a deviation, in the 1800s, the free market economists started bristling at the rise of copyright and patent, which were then known as monopoly privilege grants. And when the free market economists started criticizing this scheme, saying this is a deviation from the free market and private property, it's anti-competition, it protects producers from competition, et cetera, the response was, well, it's not a privilege, it's a right. And everyone said, what kind of right is it? It's a property right. What kind of property right is it that expires after 20 years or 15 years or 30 years? And what kind of property right is it that there's no tangible boundaries to? So the response was, it's a special type of property right. It's a intellectual property right. So that's why the term arose. The term arose as a way to defend this system. So they tried to put it into the property rights or natural property rights framework to sell it and to keep it going because it benefited certain industries at the time. But this is, of course, awkward, and the original constitutional basis in the U.S. was empirical or utilitarian or consequentialist. So there's always been an uncomfortable blend of arguments. There's been the sort of natural rights argument that if you create something, you deserve to profit, which is, in a way, it sounds Marxian, it sounds Lockean, because they never specify what you create, right? If you ask them, what did you create? You say, I created value, and that you get back to the Randian thing. So Ayn Rand and Locke and even the Marxians all have a totally confused view of the whole thing. I think that the Lockean labor theory of value is related to the Marxian labor theory of value, right? The idea that if the employer doesn't pay the worker a salary that takes into account every incremental benefit that his labor has contributed to the value of the sold product that he's being stolen from or exploited, right? And that's because of this idea that value comes from labor, like the effort put into it. And that's related, as you can see, to the Lockean theory that if you own yourself, then you own your labor, then you own everything you create using your labor, right? The argument makes sense, in my view, when you talk about ownership of scarce resources in the world. If you mix your labor with it, that simply means that you used it first and you put a border on it first, and therefore you established an objective link showing society, I'm the first guy to use this, I have a better claim than you do. That's really what the Lockean argument is good for. But by mixing in this labor stuff, you lead people to think that there's a property right in labor and therefore in action, right? Which makes really no sense. Okay, so this is how this got going, but then you have an industry of special interests that arise in the US and in Western Europe in the 1800s and especially the 1900s after the airplane and light bulbs and Thomas Edison and the patent fights between all these guys. And so then the system becomes entrenched with international treaties. And the primary argument given now is the empirical one. It's that if you don't have the government come and intervene by giving people these temporary monopoly privileges, then there will be an underproduction. There will be a market failure, basically. There will be an underproduction of innovative works. The more careful scholars don't say there would be no works, like they don't say there would never be a novel written, there would never be a painting painted, there would never be an invention invented. They just say that there would be fewer invented than would be optimal. So they recognize a market failure in capitalism, and the government's going to come in and grant these temporary monopoly privileges to give you a little extra incentive to stimulate the creation of artistic and scientific works that otherwise wouldn't be created or wouldn't be created as early or as soon. So the entire argument is that the government can recognize a market failure, can craft laws and policies and regulations to try to make us all better off. And an implicit presupposition of this argument is that there's a cost of this system, but that cost is trivial or small compared to the gains. And the gains is not the extra innovation. The gain is not innovation per se. It's just the extra innovation that people would never have done or wouldn't have done as early. So their argument basically is that if the government imposes this huge IP system on society, namely copyright and patent, despite its costs, there will be extra innovation and creativity stimulated and spurred, the value of which is greater. Now, so that's the basic claim. Now, from a libertarian and a Austrian economics point of view, there are many problems with this basic argument. Number one is the, of course, Austrian objection that value is subjective and not cardinal. That means it's not quantitative. You can't compare interpersonally values. They're ordinal, right? And they're totally subjective and personal. So the entire project is methodologically flawed, just for pure Austrian reasons. But even if we forget that objection, then the second objection would be a moral one. So the moral objection is that the argument is we should make laws by maximizing overall social utility or welfare. The problem with that argument is that there's no basis for that moral claim. It's just an assertion. And you can see many cases where it would lead to horrible outcomes. For example, you could argue that if we had a procedure that could transplant an eyeball from one person to another and give the blind person sight, and it would only reduce the sighted person's sight a little bit, but who could argue that one blind person and one sighted person after the operation, both people can see now. Now, the sighted person's vision might not be stereo, might not be quite as good, but his sight is diminished a little bit, but the other guy goes from 0 to 90%. So like it's a net gain for the world. So by such reasoning, you could argue for all kinds of horrible things where you just basically take from one person and transmit to the other. So that's an ethical problem, right? And then finally, there's the just empirical problem, like the burden of proof. In the 200 plus years since the Industrial Revolution, you would think that economists and the advocates of IP would at least in the last 100 years have had time to do some studies and to prove empirically their burden of proof, like to prove that the patent system, for example, generates more outcome, more wealth by the extra innovation that it induces than it takes away by the distortion and the costs of the patent system itself, which are mammoth, many tens of billions of dollars per year just in the US alone. And studies confirm this. The problem is that of all the studies that are done that are not just completely biased and you can throw them away, the studies by economists that look into this, they keep concluding it looks to us like the patent system on net discourages innovation or distorts innovation or leads to rent seeking or depresses innovation, or at best, we can't conclude anything. So for 75 years, 50, 75 years, economists have been saying this over and over again. Even the neutral economists who would tend to be pro-IP because they're mainstream and they're not that principled, they just look at the data. So there has been no clear evidence whatsoever. The only time you get people that claim there's clear evidence is they'll do something like they'll say the Commerce Department, which is the agency of the U.S. government that administers the copyright system, right? The U.S. Patent and Trademark Office administers the patent and the trademark system, but the Commerce Department administers the copyright system. So the Commerce Department published a study about 7 years ago, and they said something like, oh, IP-intensive industries generate 27% of American GDP, $15 trillion or $10 trillion, and therefore IP is important. Now, this is obviously specious argumentation because they're mistaking, number one, they're mistaking causation for correlation, right? Or correlation for causation. So people say that the West and the US have done great since 1800 in the Industrial Revolution, and we've had a modern patent and copyright system since then, so therefore one causes the other. Now, that's obviously fallacious reasoning because you could also argue that it's the existence of inflation or tariffs or recurring war. Every 10 years, the U.S. has had a war. You could argue any of these things that has accompanied our journey in the last 200 plus years was correlated with our economic prosperity. And so that's the cause, but that's obviously absurd too. So there's no argument there. But the other problem with this Commerce Department study is that it just says that, okay, there's an industry that has innovation in it, right? There's an intellectual aspect to it, like there's services provided, or lots of the companies in that industry use copyright or use patents, and therefore they're correlating the GDP associated with them with saying that IP is the cause of that, which is obviously ridiculous. The reason that IP is associated is because we have an IP system. And of course, publishers and movie makers and software industry and the pharmaceutical industry, right, and the high-tech industry and the semiconductor industry, they're all going to be embedded in and use and employ this system that we have, given that it exists, because they do have innovation or idea-related services or businesses. But that's no proof whatsoever that there's any causal correlation at all. So the only studies that have a positive thing to say empirically about the effects of the patent system, for example, are these kind of completely dishonest that even a non-expert can just read it. You can just read the abstract and you can see through it right away. All the careful studies are basically inconclusive, or they conclude that it hurts innovation, which means to me that it's clear that even in 2020, we still don't have a single proponent of the IP system who can meet their burden of proof of showing that, okay, we can have an IP system because, or if, or to the extent it does make us better off by stimulating more innovation and creative works. But they can't show it. They haven't shown it yet. They haven't met their burden of proof. And I think for principled reasons and other reasons, we could see why it's impossible to do, even if you omit the Austrian subjectivity grounds, and even if you omit the ethical problems, just on empirical grounds alone, they haven't met their burden of proof.
I'll add something to this. I agree entirely, but I'll just add one way in which you'll find the argument usually presented is the same way in which all kinds of stupid arguments are presented in academia, which is theoretical models. And so you'll get an economist who will formulate a theoretical model and tell you, look, we invent this fake universe in which people are not paid money to innovate, and then we invent this other fake universe in which people are paid money to innovate. and we run a simulation or we perform some mathematical equations. There are all kinds of different methodologies you can do for this trick. The result is that we construct some kind of SimCity world, and then we come to the conclusion that, oh, look, the world where we pay people to innovate ends up with more innovation. Therefore, we conclude that innovation must be good. There's an enormous amount of literature like this on pretty much every bad economic idea, because even though I think empirical economics can be manipulated to get unreliable results, it's still not very easy to get a paper published to try and argue something like in favor of, say, expansionary monetary policy. Even with empirical papers, still hard to show the results in a conclusive way. And so you end up very often relying on these theoretical models. But it's quite startling, actually, if you look at some of the papers that study the empirical record and try and analyze it. And pretty clearly, there's not a lot of strong evidence that this works. I think it's quite amazing. I'll add one more thing, which is when we think about intellectual property, there's this idea that this is the only way for people who are creative to make money. And that's the underlying assumption here, which is that if you were a musician and you didn't have intellectual property, then people would just steal your music. And if you're an author, they'd just steal your book. You'd be writing books, somebody would take it, and then they would start selling it without giving you royalties. And because they can sell your book without royalties, they can sell it at a lower cost than the publisher who wants to give you royalties. And so then you can't make money from your book. But again, this is limited imagination, and it's similar to the theoretical modeling that people do to arrive at the results that they want. In reality, I think if you're a musician, for instance, this is already the case. If you're a musician, you make at least around 90% of your income will come from concerts and from sponsorship. This is true for your local indie rock band that plays in your local pub, all the way to Madonna and Britney Spears and the biggest superstars. They of course they make money from selling records, but the majority of their money they make from doing advertisements for Pepsi and Coca-Cola and for doing concerts. And those things, that's something that copyright can't help you with, and you don't need copyright for it. You can pack a whole stadium and 50,000 people show up and pay tickets. You still make money. And we see, for instance, with music, with the spread of SoundCloud and YouTube, people don't really buy music from artists anymore. Artists put their music online for free because they've realized that it promotes them and it makes them more popular and it gets them more people to go to their concerts. In fact, Max just shared with me right now a link, which I'll add to the notes, of Iron Maiden looking at traffic from BitTorrent and finding that because a lot of people are downloading their album from BitTorrent, that helped them decide on tour locations. And I think this is very true. And it's not just true for music. I think it's also true for authors and books. I think even as an author myself, I think people still want to buy the book. People still want to buy the physical copy of the book. And people want to talk to the author. People want to listen to the author. If you have something to say that people will pay $10 for or $20 for in a book and spend 10 hours reading, the chances are there will be a lot of those people who would be interested in talking to you in a longer format. They'd take your online course. They would pay to have a consultation. They'd pay to have you come and speak to their company or to their family business or whatever. So these kinds of opportunities will emerge for people. And you don't just need the money that you make from the books. However, having said that, even in a situation where you want to think about the money from the book, you'll still be able to make money. I think a way to think about it, and I hinted at this toward the end of the lecture, is if publishers didn't have to worry about legal stuff and to secure all of the patent and to engage in all of this legal expensive stuff in order to secure intellectual property, then the books, well, at least the albums in music, this is more true, I think, and in drugs, it's even more true. Drugs would be far cheaper if pharmaceutical companies didn't have to spend 5 years in court suing each other for every drug for intellectual property. And if they didn't have to spend so many years trying to prove intellectual property in court, that would save a majority of the cost. And in the book by Boldrin and Levine, They argue that a majority of the costs for developing a drug right now have nothing to do with the actual development that takes place in a lab. The development that takes place in a lab, you've got starving graduate students and postdocs slaving away day in and day out in order to come up with new things. And then you run trials and then you get patents and so on. But more and more of the of the pharmaceutical companies' resources are going toward the legal stuff and toward lawyers than it is going toward scientists. And that's because of the patent industry. So if you got rid of that, if you got rid of the concept of intellectual property, then as a pharmaceutical company, if you find a cure, you don't have to convince anybody of it. You can just put it out on the market and you can start selling it. So the first mover advantage that is provided to you by the fact that you're able to put the drug first on the market, and the reputational benefit that you get from being the person who invented it, is going to give you a big head start on everybody else. And if the costs don't, and if you don't have those massive costs for lawyers, then I think the extra premium for the work producer is not going to be large enough to make the work extremely expensive and then encourage generic imitators to come and take your lunch. In other words, the reason we have piracy and the reason we have generic drugs is not because it is actually because the intellectual property system makes things far more expensive. So I think consumers would be better off, and the producers of content would be better off if they could interact with each other freely. And this is really what the publishing industry is about, whether it's publication or production of music. The point is to get the content from the producer of the content to the consumer. And so the job is to do that as efficiently and as cheaply as possible. And if you're not able to do it cheaply and efficiently, then people find cheaper and better ways of doing it. But the publishing industry has essentially frozen us in time in their publication and distribution methods. At least with music, this has changed significantly over the last 10, 15 years. But up until 2000 or so, the world had gone digital mostly, but music was still being sold in CDs because, because it benefited the public, it benefited the production companies that they continue to sell physical discs, because that helped their intellectual property model. But what benefited consumers and producers of content, of music, was to make it as free as possible, to post it online for free, so that the listeners would listen as much as they want, and so that people could enjoy it, and so that the users could promote their work more and more. Yeah, so this is what I wanted to add. Anybody want to add anything?
Before we field some questions, let me add a couple things about the FDA system. I just added a few links that people could find of interest related to all this. One of the types of IP is called trade secrets, which we haven't talked much about. So there's trademark, trade secrets, patent and copyrights. There's a few others: space rights, moral rights, semiconductor, mask work, boat hull designs. But the main ones are those four, and the main two are patent and copyright. Trademark is pretty harmful too, in my view. But so the idea of a trade secret is that you can just, as a practical matter, just keep some of your proprietary processes. You just don't reveal them publicly, so you keep them secret. You don't need a law for that, but the trade secret law gives you some extra remedies, which I think are also unlibertarian, because it allows you to use government court force against people that don't have a contract with you. But let's leave that aside. The point is, the purpose of patent law, technically speaking, if you read the statute, is not to encourage innovation, but it's to encourage disclosure. That is, not to use trade secrets. So the idea is that instead of you keeping your ideas secret so that they won't spread as quickly in society, which is, I think, a dubious assumption, because when you sell a product, most people can reverse engineer it or see what the features are, or you're advertising the new features. So it's almost impossible to keep your innovations secret, except for a few processes of making chemicals or something like that. But in any case, the justification given for patent law is that the government will make what's called the patent bargain. We will give you a monopoly for 17 years over your invention if you disclose it to the public. That's called a patent disclosure. That's what a patent application is. That's why the word patent comes from the original term letters patent, which means open So if you choose to forego trade secret protection and drop your panties and show the world what you have, and you teach them something, they can't use it right away, but they can use it in 17 years. At least that advances the progress of science and the arts. That's the idea, right? Now, with the FDA system, it's not just the patent system that distorts it and impedes it. It's also the FDA system itself. The FDA system is a huge regulatory system, which results in quasi-patent grants itself, because a generic has to jump through hoops even after the first guy's monopoly expires before they can compete. But finally they get the right, but it's like a temporary thing. But the point is, during the FDA process, the person applying for the FDA approval has to spend all this money on lawyers and other personnel to get the approval done, and they have to reveal their secrets. In other words, by the time you get the FDA to approve your drug, let's say 7 years down the line, everything that you're working on is public. In other words, your trade secret has been ruined already. You couldn't have relied upon trade secret like you could in a private free market as one of the alternative ways to extend your first mover advantage, right? Oh, okay, I have a first mover advantage. I have a reputational advantage because I'm the first guy that makes Tylenol, and I can rest on that for a while. And there will be competition eventually, but it will be slowed down because they don't know how I'm making it. But guess what? Now they do know how you're making it because you had to reveal that publicly to get the FDA permission. So what you have is you have one federal governmental regulation, the FDA system, which then the advocates of the patent system, which is another governmental regulation, use to justify it. They'll say you have to have patents because the drug permission process is so expensive and you have to reveal your secrets. You can't rely on trade secrets anymore, so you have no choice but to use patents, so we need patents. So this is what Mises always said: controls breed controls. If you have the FDA system, you need a patent system. Now, of course, chronologically, they get it backwards because the patent system started in 1790 and the FDA didn't come till a century or so later or more. And so now they're justifying a later regulation. They're justifying an earlier regulation, saying that it's needed in response to a later regulation. So their chronology makes no sense. But this is how these people argue. It doesn't occur to any of them that, hey, why don't we get rid of the FDA system and the patent system, and then let people use trade secrets when they want to, let them issue drugs when they want to, let people try them if they want to, as long as they assume the risk, and just get the government out of it. Trump is trumpeting the fact that they have this compassionate use exemption where they will stingily, miserly give permission to someone who's on their deathbed to try something that might be dangerous, that hasn't gotten full FDA approval yet. And they act like they're giving them they're bestowing some favor upon them by letting them do what their natural rights would let them do anyway. So that's one thing I would say. I put some links, by the way, in the public chat that people can go link it to. Like when Dr. Moose was talking about concerts and artists and musicians, you can think of any kind of way that people would make money and find ways to profit in a free market where they couldn't rely upon protectionism. A novelist like J.K. Rowling, who wrote the Harry Potter books, she wrote that on a subway as a working class mother, and she got a fan following after book number 1. Even if she had done that for free on Kindle or something like that with no copyright, and there could be knockoffs, she already had millions of fans at that point. She could have simply put out an Indiegogo thing and said, all right, I've got book number 2 and 3 written, and I'll release them as soon as I have 5 million subscribers or pre-orders. And then if a movie was made of it, there might be 4 movies being made, because you don't need permission to make a movie. So there might be 4 movies being made. Maybe one of the producers of a movie would say, if we get Harry Potter, J.K. Rowling's endorsement and consultation, we'll make more money because the fans will think we're the authorized movie and we will get more ticket sales. And they would say, hey, J.K. Rowling, you're the author. Why don't you consult on this movie and we'll give you 5% of the ticket sales and you authorize it, and then we'll do better than the other 3 knockoff imitators. There's lots of things people could do and would do, and you could already just do the numbers. You could see she'd be worth $500 million already after these 7 novels, even without copyright. Now, will poets make a lot of money? Maybe not, but they don't make a lot of money now. Copyright doesn't guarantee profits anyway. So in the end, we have to realize that questions are not arguments, and you'll get this all the time. You'll have someone say, if you're against IP law, how would I make money selling this? I'm like, I don't know. That's your job. On a free market, your entrepreneurial business model is not my problem. You figure it out. If there's something that's not profitable, then you shouldn't do it. This is the way it works. And the idea that everything that we do now would be sustainable without copyright or patent is not true, because it has an effect. It distorts the market, which means it makes some things more profitable now than they otherwise would be, and it makes some things less profitable than they otherwise would be. So if we remove the government interventionism and the distortions it's causing, things will change. And we free market advocates and we believers in the dynamic economy and private property rights, we shouldn't be afraid of change, especially when it's a reversion back to a norm that government intervention has distorted us away from.
Yeah, I think there's something quite illogical about this argument that J.K. Rowling would be publishing all of those books and people would just steal them and she wouldn't make money. It just assumes that somebody's fans are out to get them, which is just a very strange assumption. If I like the Harry Potter books, I'm not going to be thinking of how do I screw over J.K. Rowling out of making 50 cents on each copy of the book that I make. And I think ultimately the difference between the publisher who publishes the book along with J.K. Rowling's permission, if there was no patent and no copyright, getting J.K. Rowling's permission probably adds 50 cents or $1 or $2 to the price of the book.
Absolutely.
And that's definitely worth it. And I think it's worth it for the fans to pay that extra. But it's also because if I go as an author and I say, you know what, only buy from this publisher, that's the one that's paying me, please don't buy from the other publishers. I think the majority of the fans would prefer to buy from the publisher that is linked to me, even if it's 50 cents more.
Yeah, and on the other hand, you might have lots of poor people in Africa or India or China or something who are not the fan. They're not the purchasers anyway, because they can't afford it. They might download a pirated version and read it for free. That doesn't hurt her. It only gives her more fans.
Yep.
Yeah. So the whole idea is just, and not only, I hear people all the time confuse fraud and plagiarism with patent and copyright. And they also confuse patent, copyright, and trademark, because it's hard to keep these distinctions separate because it's a highly specialized, arcane legal field. It's like knowing the U.S. tax code inside and out. Most people don't know it. But plagiarism really has nothing to do with copyright, and fraud really has nothing to do with copyright. So you'll hear people say something like, if there was no copyright, I could just take J.K. Rowling's Harry Potter novel and put my name on it and make millions of dollars. And it's, first of all, that's not what copyright stops. Copyright stops me from selling J.K. Rowling's novel with her name on it. That's what they're really upset about. Because if I published Stephen Kinsella, Harry Potter and the Philosopher's Stone tomorrow, no one will download it or buy it, because they're going to wonder, if I change the name, what else did I adulterate in it? In other words, they want the original thing. They want an assurance of quality, a guarantee. And if I'm messing with the name of the author and just lying blatantly, I'm not only going to be a laughing stock, but no one will even trust it. Why would you waste 7 hours reading a book and you're not even sure if it's the authentic original book? It makes no sense. On the other hand, if I'm some upstart writer and I want, like Kurt Vonnegut, some modern writer, Cormac McCarthy or whoever, even someone more modern, right? The Vampire Girl or whatever. And I want to say, here's my interpretation of Harry Potter. People know what that is, and that's called a derivative work under copyright. There's nothing wrong with that. If I wanted to write a sequel to Atlas Shrugged tomorrow, everyone would know Ayn Rand didn't write it, and some people might want to read it. There's no fraud, there's no plagiarism, and there would be copyright infringement, but it shouldn't be. So there's nothing wrong with, or it's the same thing with fan fiction. What's wrong with fan fiction? What's wrong with reading a Star Wars or Star Trek universe novel written by an amateur on the side? There's no fraud. There's no plagiarism.
And I think the market can provide for ways of policing that are very straightforward. I think it's a website like Amazon, for instance, wants to maintain a good relationship with authors. And so if somebody takes my book, which has happened actually at some point, somebody put my book into, it seems, a Chinese translation, and then translated it from Chinese back to English. And it seems they made a mix of my book and Andreas Antonopoulos's book. And so you would open the pages, and they posted it on Amazon, and somebody bought it, and they shared some pictures with me on Twitter. You'd open the pages, and it'll just be some vague paragraph that sounds like a paragraph from my book, and then a couple of paragraphs from Andreas's book. And it was posted on Amazon, but Amazon removed it because this is what Amazon does. Amazon has no reason to be taking away revenue from real authors that are making them money and giving it to scammers. And so these market institutions, they're not made up of idiots, and they care about their interests.
One example I give sometimes is, okay, in the field trademark, right, which is about you have to have a reputation, right, and a legally protected name for a product or whatever. So imagine like Crest toothpaste, okay, and most people would buy it at the local drugstore like a Walgreens, or maybe at the supermarket like Kroger, okay, a big chain. Okay, theoretically, if there was no trademark law, there could be a knockoff Chinese, a company that makes fake Crest toothpaste, right? And then they sell it to Kroger for a cheaper price because they're a knockoff, and Kroger sells it. Now, either the customers will find this out or they won't. If they don't find out, that means the quality, I guess, is identical, and who really cares? Who's hurt? But usually people will find out. Someone will leak it. The customers will get wind that, hey, I'm going to Kroger and I'm depending upon Kroger to deal with reputable vendors, and they're selling fake Crest. All of a sudden, Kroger would lose 2/3 of their customers overnight. There's just no way they're going to do that. It would be like if you go to Hertz and you rent a Toyota and it's really a fake Chinese knockoff of a Toyota. As soon as wind of that gets out, so there's all these obvious market incentive structures that keeps middlemen, basically, or the people that are the purveyors, they're going to have an incentive to deal with a reputable seller of the good and down the chain. If you just imagine like a fake McDonald's opens in Times Square. Okay, to open a McDonald's in Times Square, you have to rent space, you have to have employees, you have to spend a lot of money. Which person that has a lot of money, or which set of investors is going to do that if they think that this is not really legitimized it's not authorized by McDonald's? So it's basically a type of, you're defrauding your customers. So eventually you're going to get sued by a class action in a fraud case. Like all your customers think they're buying McDonald's hamburgers, or they're not. So you're lying to them. So obviously the business is going to fold and collapse within a few months. So who would invest in that in the first place? Like everything that the IP guys put up, it makes no sense whatsoever. I don't know if we can do this, but can I try to share my screen real quick just to show you something? Yeah, absolutely. Let me try this because I haven't done Zoom very much.
Yeah, just in the middle there's a green thing, share screen.
Yeah, I'm hitting that. Oh, wait, hold on. It's asking for system preferences. Zoom. Let me permit this real quick. And then we'll go okay, let's see. Can you see this? Can you see this chart here?
Yeah.
Can everyone see this little curve?
Yep.
This is going back a little bit. This is from one of my posts. It's about Alex. And this just gets to my point that even libertarians they sound like they're on our side on the IP issue. They're basically empiricists. They don't have the fundamental understanding, and therefore they never go all the way. They never, as we call it, strike at the root, right? They never get to the fundamental issue, and they never want to make principled statements like we should abolish IP law, or the whole thing is anti-competitive and anti-competition. So they'll say we need to reform IP law. We need to improve it, or they'll say it's broken or it's gone too far. And a good example is this guy, Alex Tabarrok, who's one of these George Mason types. And so he just makes this assertion. You'll see this here. He says, this is patent policy on the back of a napkin. And this is his argument for why we should reduce patent strength, which means we should reduce like the patent term or the types of inventions it can cover. So he just draws this Gaussian curve, and there's a peak, right, which is this Chicago idea that there's a market failure. That's the zero on the left, right? We have this much innovation without a patent system, but we can get more innovation if we start adding some patent protection. But we've gone too far, so we're on the other side. This is like the Laffer curve, by the way, the idea that our taxes are too high because we're reducing government revenue. This stupid idea that you can reduce taxes and make more government revenue, but there's some optimal. So this is his assertion. So here's the optimum, and we are here. He says this, but he gives not a single data that shows this. Like, there's nothing in his data that shows where the optimum is, that there is an optimum, or that the curve is shaped like that. I think the curve is downward sloping from the origin. It just goes down. Like, the more patent protection you have, the less innovation you have. Anyway, I just want to experiment with showing this. I know how to do this from now on. I've learned something. Did you want to address the questions that you sent me earlier, or what do you want to do?
Tim has a question that he wanted to ask. So, okay. Tim, could you? I think I need to unmute you first, but we need to.
There we go.
Yeah. Okay. Great. Where's Tim? There you go.
Am I unmuted? Can you hear me?
Yes, we can hear you.
Yep.
Hi. Yeah, I'm not sure I've got a really succinct question, but copyright's something I've dealt with my whole life, and I'm a filmmaker, but I was a photographer for many years, and copyright was a hugely important part of our business model, and I was always an advocate for it. And in the last few years, I've, like most people, just adapted. I saw what was happening, and we started finding ways to make money elsewhere other than through royalties and stuff. But so I'm not necessarily an advocate for or against it. I'm just following the market and seeing where the best way to make a living is. But in photography specifically, I've always thought, I mean, I felt strongly about it, mainly for some kind of a moral reason, because you don't like the thought that you put a lot of effort into something and then someone just takes that thing and makes it their own. And that's happened to me a number of times. I've spent a lot of money producing a piece of work, which is then taken and used by another company, even on their sort of advertising. And in a way, I think you were talking about innovation. In photography, I think innovation is stifled by stealing of imagery. There's specific examples, like often I make an agreement with the people who I'm photographing. That's very common for myself. And then as a result, when I release photos to a very specific place, I need them to adhere to the rules that I had and the agreement that I had with the people in the photographs. For example, if I say to someone, look, you're opening your life up to me, you're allowing me to photograph you, I'm not going to use this photo to advertise like kind of toothpaste, because it wouldn't be cool. But someone could then just take that picture and advertise toothpaste with it. Or am I misunderstanding the difference between fraud and copyright, etc.? But if people were just stealing imagery left and centre like that, it would change the way I work. I wouldn't do those kind of things. So it would stifle the kind of work I was doing. And the other way often that it happens is people steal my imagery and it appears. I've got some photos which have become brands in their own right. They gain sort of notoriety. And then when people use them, it creates the appearance that you're endorsing the thing that they're using them for. And that has an effect on you directly. And, you know, they're all reasons why I've often felt in the past that I want to be able to at least somehow control what happens to something I do after it leaves me. But yeah, I don't know what your thoughts are about photography specifically, because it's like I say, it's something I've dealt with for many years, and royalties used to be a huge part of my income stream. I'm like safe now, like I get more money out of public speaking than I do out of taking photos. I have done for about 4 or 5 years. So you just find the way. I don't care any which way about copyright, but I do think it's immoral for someone to steal something that you've put your heart and soul into, and often you've spent a lot of money doing, which is also what happens photography-wise with publications, where there are lots of companies out there whose business model relies on basically just taking imagery and using it on their sites. And even you could argue Instagram and these kind of models. And it certainly has caused a lot of photographers who don't have an alternative stream of income to stop working and to stop taking photos, because they can't find a way to make money. I understand at the J.K. Rowling level, you don't really care about it. But at a small level, you care. If you put your heart and soul into something and then you can't actually generate any money off it to start with, you often just give up and try something else. But I don't know. I just wondered what your opinions were in the realm of photography and copyright.
Safe, do you want to take it or you want me to?
To be honest, it's not something I've thought much about, but a couple of initial ideas is this isn't very nice to say, but maybe there just isn't that much market demand for that many photographers to be taking that many photos. And the copyright law is essentially creating a misdirection of resources by providing so much more financial incentive for people to be taking so many more photos when maybe there isn't that much demand for it. One other thing I'll say is that in a free market, if we didn't have copyright, we'd have some other mechanisms for making this happen. And so, sure, it'll happen occasionally that some random person somewhere will take a picture that you made and put it on their website. But I think if it were to happen in a manner where it is actually systematic, then I think these companies can be boycotted effectively by their customers and suppliers and producers or other photographers. There are these mechanisms, the same way that I was mentioning the example of why Amazon would want to get rid of the knockoff book or why Kroger would not want to use the fake crest. There could be things like this happening in something like photography. And maybe there's still a lot of money to be made from all kinds of different photography. Like you just photograph people's for weddings or photograph special occasions.
Right.
There's a lot of money to be made from that. And nobody wants to, or very few people want to steal that kind of work. And anyways, they can't really steal it because you're going to be sending it to the buyers. So maybe if we do remove copyright, yes, maybe it does mean that some photographers will have to switch from taking pictures of beautiful scenery and posting them online and having them stolen. They'll switch to something more concrete like photographing weddings and special occasions. But there's always demand for something like that, I think.
Or working for a company as a photographer or something like that.
What about how do you feel about the actual kind of moral side of it? That if you, I'm sure everyone here, if you knew someone had put their heart and soul into a series of photographs, for example, you wouldn't just take them and use them. There's a sort of certain moral unfairness to that. And that's certainly how it feels anyway. I don't know whether...
Absolutely.
You mean to comment on this, Saif?
Yeah, please.
Yeah.
Okay, so I've many things on photographs are an interesting thing. Number one, so the agreements that you negotiate now are against the backdrop of an existing copyright system. If there wasn't copyright, the agreements would probably be different, right? They'd be based upon a different set of presuppositions. Like you wouldn't be presumed to be the owner of the photograph. Copyright law on photographs is perverse and absurd. Are you aware of those there's a certain type of monkey that took some photographs, and then the question was, is there copyright in those? Is there an author? Is there a human author? Does the owner of the monkey own the photographs? I mean, there was a debate in the beginning about whether photographs should be subject to copyright at all, because in a way they're just facts, because you're just taking in light that depicts a factual reality, like maps. Like in the US in the Feist case, maps were held not to be copyrightable because they're just depicting a factual layout of the earth. And like databases are not copyrightable because they're just factual arrangements of information. Even if there's work put into them, there's no originality because you're just depicting what's true. But the courts have said that, yeah, there's an artistic aspect to how you aim the camera, how you do the settings, how you choose when to hit the timer. But in a sense, a photograph is just a record of a factual matter in reality. So you could argue it shouldn't be copyrightable in the first place. And you're using words like take and steal, which are loaded words. To steal implies there's property in it, but the question is, should there be property? And there's not a better English word really except copy, but no one really takes your photograph, they copy it. And you could argue that if you have information that you make public, then you can't really complain that people use it. If you want to keep a photograph private, you can keep it private. But it's like a fact. If you admit that you have 3 nipples for something weird, once that fact is made public, then people know it. They can't be expected not to act upon that fact. And I don't see the fact of the pattern of data that represents a photograph as being different in principle, in kind, than any other kind of fact. Once knowledge gets out there. So if you give someone a photograph, you know that it can be digitized. Now, the other point is this, even with copyright law, which we have now, there's no stopping people from copying your pictures because we have digital technology, scanning, torrents, encryption, the internet, and sharing. Memory's cheap, almost free now. So once you release data out there, including an image, it will be copied. So copyright law can't stop that fundamental fact. I think Cory Doctorow, the sci-fi author, said that the internet's the world's greatest copying machine. And from this day forward, copying will never get harder. It's only going to get easier. So even if there is copyright, anyone who relies in their business model upon people not being able to copy things that they make public is just deluding themselves, right? Have to come up with a different business model. You had to make one more comment. You had something about, one more point about the absurdities of copyright in photographs. Under copyright law, the author is the owner of a work, which means the photographer. So if you're on vacation at Disneyland and you hand your camera to a stranger to take a picture of your family, theoretically, that guy is the owner of your copyright and of the photograph, the copyright of the photograph. And if later on you want to make prints of your family photo because it's a nice picture, theoretically, you're violating the copyright of some stranger whose name you don't know. It's all completely absurd. And then you have to come up with weird arguments like there was an implicit license because you gave it to him and he knew you were going to use it. But that's not how photographers work. Photographers go crazy when you pay them to take your picture and then they make a scan of it because they want to pay your inflated fees for the digital originals, which your contract could cover, right? And then they go have prints made at the local drugstore. Everyone freaks out about that. But eventually these kind of complaints are just going to go away because it's just impossible to stop people from using their own printer and their own scanner to make copies in the privacy of their own property. You can't stop it. So you have to come up with business models that work around that.
There was a quote from the Wendy McElroy paper, which I posted on the notes for the lecture, where she says, I can't remember who exactly she was quoting, but
Benjamin Tucker, yeah,
exactly.
Yeah.
If you open you have a property right in the money that's in your safe, but if you open your safe and you throw the money in the street, you can't expect people to respect the property right and collect the money for you from the street and bring it back to you. I think it's the same with information. You can keep your photos if you don't want to share them, or you can share them only with watermarks and share them with people who only pay for you without the watermark. And then you can have mechanisms for detecting if people are, for instance, you could add a couple of barely visible or even invisible mechanisms into different people's photos so that you would know who's the one who's leaking the photos from the people who are buying it. Ultimately, I think it's just the framework that fund proposes and the clarity of just understanding that information cannot be knowledge, that information cannot be property, is just so much more consistent and neat. And I think the world will find a much more peaceful and productive way of fitting our business models around it because it is peaceful.
The way copyright hurts photographers too, because a lot of times you'll take a photograph and in the background there's some kind of sculpture or a building or mural or someone's face. And like documentary makers have a horrible time with this, filmmakers, photographers, because now they have to go get permission or blur certain things because they might be infringing copyright if you take a picture of a sculpture that has a copyright in the sculpture. So it limits the freedom and it distorts, it must distort the choices that photographers and filmmakers make. Like, I'm going to choose, by the way, I have it on my website. There's some bizarre cases where, okay, there's a famous picture of, I don't know, the Grand Canyon or some kind of natural, it's not even a man-made thing, it's just a natural site. And so there's a photograph in that picture because the photographer chose the time of day, they chose the time of year, they chose the lighting, they chose the angle, exposure, all these things, right? Someone else goes 5 years later, 10 years later, and they set up their camera in exactly the same location, and they take a similar picture, and they've been accused of copyright infringement because it's a copy of the original picture, even though it wasn't a copy. It was just a recreation of the of the environmental background that led to the first picture. So you have these totally absurd results. And to me, it's like in math, if you allow a divide by zero error sneak accidentally into your mathematical equations, you can get any result. Once you divide by zero, you can prove anything. You can prove 2 = 1. It's easy to do. I can show you. And it's like that to me with copyright. Once you permit the concept of property in ideas, where the concept of property is meant to protect the underlying medium or the scarce resource that ideas are stored in, once you subvert that basic principle of property rights, then any absurd results are possible. You can get almost any unjust law that you want if you allow property to deviate from its original purpose, which is identifying the owner of a conflictable, rivalrous, scarce material resource, which is what you're doing when you try to give a property right in the pattern of information, the way a thing, an owned thing, is arranged, right? So you get these absurd consequences. And just last week, I believe it was, there was a Supreme Court case where the question was, can there be copyright by state governments or by the legislatures of state governments in basically legislation issued by the state legislature, or in annotations or comments, official comments approved by the state legislature, or in court decisions issued by government courts. Now, in the US system and in most government systems around the world, I believe, there's a policy where, like the federal government in the US, they don't claim copyright in government authored works. That's just a federal law. But that's not the law in states. So the question is, can state governments use federal copyright law to claim a copyright in their statutes and in the comments to their legislation? And the Supreme Court finally said no. And their argument was a contorted one, though. They said that to have a copyright, you have to be an author. But the author of legislation is really the people. It's not the legislators. And so therefore, you have to have public access to laws, and you couldn't have a copyright in those. So sort of recognizing in their gut that copyright law leads to absurd results, I actually think copyright law does mean that state legislatures could copyright their court decisions. States can copyright their court decisions and copyright their statutes and the comments. And yes, it would be absurd because people would be bound by laws that they couldn't necessarily even make a copy of or read because the state controls the copyright in it. But that's just a consequence of the absurdity and the injustice of copyright law itself. But the court shies away from these harsh results sometimes and just does results-oriented reasoning to bend the law to avoid a harsh result. But they don't bend the law to avoid harsh results in everyday life, only when it affects the government.
Yeah.
When someone goes to jail, Aaron Swartz, you guys probably know this guy. He was this genius young kid, brilliant computer science guy. He invented RSS. He put a laptop in a closet at Columbia or somewhere and uploaded a few thousand of their academic papers, which make no money anyway, to the internet. And he was threatened by the federal government for life in prison, and he committed suicide. There's criminal teeth to these things, and it's absurd. There's a guy who went to jail for a year in federal prison because he uploaded one copy of the Wolverine movie from about 10 years ago. Copyright law leads to insane results, but you can't expect the courts to try to tamp it down on some pretense that we have this rule that says any law that's ridiculous, we won't enforce. The law is ridiculous. So you can't get rid of that without getting rid of the law.
Yep. Okay. Daniel, you had a question you wanted to ask?
Yes, please. Thanks, Safe. I touched on it at the end of our session on Monday, actually, because it's a really interesting case study. If you look at what we've been talking about, patents just enriching lawyers, you just have to look at the Samsung versus Apple case that dragged on for 6 or 7 years and just enriched lawyers all over the world, from Southeast Asia to Europe to America. And I brought up the case of Tesla, Safe, at the end of our session on Monday, and they got rid of all their patents back in 2014. And I'm just going to read from the original blog post from Elon Musk when he states, "When I started out with my first company, Zip2, I thought patents were a good thing and worked hard to obtain them. And maybe they were good long ago. But too often these days, they serve merely to stifle progress, entrench the positions of giant corporations, and enrich those in the legal profession rather than the actual inventors. After Zip 2, when I realized that receiving a patent really just meant that you bought a lottery ticket to a lawsuit, I avoided them whenever possible. The question to Stefan is, this is 6 years now that they took all their patents down and opened up really open source to their manufacturing competitors. We've not seen anywhere near, I think, the innovation that anyone was expecting in the electric car market from the big automakers. Do you have any thoughts around that at all?
Okay, on the enriching lawyers question, and I could incidentally quickly answer one of the offline questions that Saif had gotten earlier from a student. My guess is that without a patent, without the state legal system, half to 2/3 of legal jobs would disappear. So probably half the legal profession is doing things that don't need to be done. You don't need patent lawyers, you don't need tax lawyers, you don't need drug defense lawyers, you don't need these kind of lawyers. On the other hand, I believe that in a private property order, which was prosperous and successful, you might have more lawyers employed for contracts and for arbitration and disputes because there'd be more and bigger deals, which you could benefit from getting legal advice from. So you could afford, if you have $1 billion deal as opposed to a $1 million deal, you have more of an incentive to get the lawyers to help you get all the details right. So I think there'd be an enhanced market for attorneys for private transactions, but a reduced market for attorneys for all the fields of law that shouldn't exist. So that was one answer. And yes, of course, lawyers absorb a lot of the costs of the patent system, although I think it's only a minor part of it. Yeah, Samsung and I forgot who the opponent was. They go back and forth for years, and the lawyers get tens of millions in fees and lots of other specialists who you have to pay. And then they finally settle, and then that means that there's a royalty paid back and forth between the big players, but only they can afford to do this. So the small innovative upstarts who would compete with them are locked out because they can't compete because they'd be sued out of existence because they don't have their own patent silo to fight back with. So it creates cartels. The patent system creates cartels or oligopolies. Yeah. And what this means is the oligopolies don't innovate as much as they would normally have to. And they have other costs like paying royalties back and forth to each other and paying these lawyers' fees. And of course, they just pass a lot of these costs on to their consumers in the sense of increased prices. So the consumers pay with reduced innovation and with reduced choices and with higher prices. So yeah, that's why most patent lawyers are in favor of the patent system. It butters their bread, and that's why they all hate me. Now, as far as Tesla, I don't want to be critical of Tesla or Musk or any of these guys that are half-assed or half-hearted about it. Like Mark Cuban, who pretends like he's against IP, just like Alex Tabarrok and these other guys. They act like they're against IP or patents, but they're not really against it. They're just against. Mark Patton endowed a chair at EFF called the Chair Against Stupid Patents. So you see the implication is there that we don't want ridiculous patents, but a good patent is fine. So they're missing the point. The stupid patents are not the problem because they don't hurt anyone. Because if someone sues me with a stupid patent, that is a patent that shouldn't have been granted, I've got a defense. I can go to court and I can hire some lawyers and I can say this patent shouldn't have been granted and it will get invalidated. So they can't really extort too much money out of me for that. It's the good patents that are the problem, right? Because those can't be invalidated and I have to pay an extortionate fee and they reduce competition. Now, given the way the patent system works, so Tesla, for example, they didn't really give up their patents as far as I understand it. I'm sure they're still acquiring patents. And how did they give up their patents? They just made a press release saying our policy now is to give up our patents. The only company I know of that's made a serious effort to do this is the Creative Commons thing, which tries to have a license, the software industry, which tries to have these GNU licenses or whatever, but the Creative Commons license for copyright, I'm not even sure if that's binding legally. It's not their fault, but it's because there's no contract, right? Contract requires offer, acceptance, consideration. Where's the offer? Where's the acceptance? Where's the consideration? If I just have a statement on my website, this is published under Creative Commons, who's the other party to the contract? What consideration did they give me? So it's very unclear whether And what if I just erase that notice later on? How does the guy I sue for copyright infringement later, how does he prove he had a license from me? What if he didn't make a screenshot of the image? The whole thing is ridiculous. In terms of patents, the only company I know of that made a serious effort was Twitter. Twitter was trying to say, we're going to only use patents defensively, which I think is the only moral use of patents. And the way they did it was they made an employment agreement with their employees saying that every inventor of a patent has a co-license with us. And if we ever assert this patent offensively, aggressively against an innocent victim, then we have to get the permission of the employee. So there's a potential roadblock. We're trying to handcuff ourselves from asserting our patents in an aggressive way. Like personally, I have no problem with using patents defensively. If someone sues me for patent infringement, I'll sue you back. That's why I have to have a patent trove. That's why Tesla, no doubt, is still applying for patents, because they need to defend themselves in case they get sued for patent infringement. So all Tesla did was issue a press release saying, we're going to allow anyone to do this. But that's not a license. Maybe it's an offer to negotiate a license, and maybe there'd be something called estoppel in the common law. If they sued a competitor for infringing their patents, the competitor could go to the jury and say, listen, we didn't have a technical license, but they did make a statement 7 years ago on their website saying, hey, go ahead, everyone can use our technology. But that's not really how you do things legally. I guarantee any big company who's going to have an investor or a board of investors or a venture capital fund, or they're going to spend millions or billions of dollars to research a new engine or something, and they need to rely upon Tesla's technology, they're not going to rely upon a press release from 5 years ago. Their lawyers are going to say, you need to go to Tesla and get them to sign an actual license. And then Tesla's going to go, I don't know if I'm going to give you an irrevocable license forever for no fee. I don't know. So it's all just PR nonsense, I think. So it's a move, a slight step in the right direction, but it's all just like trying to pretend. It's like saying that our employees promise never to take Social Security or welfare. Okay, good for you. But the system's still there, and people are still going to take it, and it's still going to affect the market as long as it exists. So as far as innovation in the electrical industry, my only assumption, I haven't looked at it into detail other than what I've just said, I would have to assume that, as usual, innovation in any field is always impeded by the existence of what we call a thicket of patents by a certain number of companies. So I do believe that the patent system has probably slowed down innovation in electrical or battery-powered cars and things like that.
One way I like to put it is that patents are a tax for standing on the shoulders of giants. You know, Newton said, if I could see further, it's because I stood on the shoulders of giants. And that's every innovation, every single thing. Any new innovation being introduced on the internet right now is being introduced because it's being built on a giant stack of technologies that preceded it, all the way from the invention of the zero to the invention of Zoom. We've had millions of things. And now if I was going to introduce a new startup idea or a new software idea, I'm going to be building on all of that. And so when you have a patent all along, that just increases the number of people that I need to have my lawyer contact and pay and make sure that everything is fine, and increases the number of people that could sue me. And that's just an enormous drag on innovation. And I think with time, it's only going to get more complicated. And that's why we see that open source continues to make so much more progress. In Linux is the operating system of the world. People still use Windows and Mac on their desktops, but that's really just because it's the consumer experience. But the infrastructure of the internet and the servers and pretty much everything other than the desktop, all the mobile phones and everything pretty much other than the desktop is become open source. Everything that's mission critical is open source because it's just a much more reliable way of innovating, because every time you innovate, you don't have to pay the tax of all of the shoulders giants that you have to pay for. Max, you have a question? Please go ahead.
All right, can you hear me?
Yeah.
Okay, so my question is inspired by Andrew Kinn's book. I guess it was 2007, I think.
Sorry, who's the author?
Andrew Kinn.
Okay.
I can write it down afterwards. It calls The Cult of the Amateur. He's all for property rights and all that. I think he has a point but I'm thinking maybe we can turn that thing upside down and turn that into an argument against copyrights. He talks about what he calls internet, the first stage of the internet, and the internet 2.0. So in the beginning, the internet was accessible to anyone, but everybody could access content, but very few people could produce content. And then in the second phase, everyone can have a blog, a YouTube channel, and so on. And he was saying, okay, that's good because everyone has a voice. It's very interesting. It's very decentralized, but this has very bad consequences. And he focuses on journalism and musicians. He says everyone can be a journalist and give your own version of the facts. That can be good, but you don't know what's true or false anymore. And when it comes to music, he wrote that when this whole business of MP3 files and so on was in the beginning. And he said, okay, if you are a very famous artist, we talked about Iron Maiden now. So by the way, this is the DVD that came after those concerts. They profited a lot from that thing. So if you're Iron Maiden, you can make a lot of money without selling CDs. If you have an indie rock band playing in the pub across the street, who cares about your CDs? You make your money there. But Andrew King says, okay, what about the guy in the middle? What about that jazz quartet, which is not like Dave Brubeck? Okay, they had to study a lot. They paid a lot of money for the instruments and all that. They're professionals, and they are not Iron Maiden. They cannot play for tons of people. And if you don't prevent piracy, you're gonna kill them. Basically, they're gonna do something else. So we are gonna end up with very successful artists and the amateurs. So my point is, okay, one answer could be what Kinsella just said. Maybe if there is no market for you, too bad for you, go do something else. It's your problem. But maybe we are looking at this from the wrong angle. If I care about that musician or book writer or whatever, that guy in the middle, he's not very famous and he's not the amateur just doing his hobby. If I care about that thing, if I value that work, that piece of art or whatever, and that guy is almost giving up, it's up to me to pay money for that thing through crowdfunding or something else. Aren't we putting the responsibility on the shoulders of government and all that, instead of saying, hey, if I like that thing and I want that to exist, I'm gonna pay money because I value that. I'm gonna pay twice as much as I used to pay because I want that thing to exist. If I don't do that and they go out of business, they go do something else, it's my fault. Would that be the libertarian take on this?
I think so. I think it's the simple answer is you and the people who care about them should just pay them more rather than throwing other people in jail, rather than ask me to fund throwing innocent teenagers in jail because they downloaded MP3s. And I think for that band, if you're not famous, I just don't see how piracy can hurt you. I think, the amount of people that would be open to if you're a small band in somewhere in the US, let's say you're a Chicago jazz band and you play somewhere in the US and you sell some CDs, the number of people who are going to hear about you in the rest of the world is very tiny. But if you put your music for free on YouTube and on SoundCloud, and then people start sharing it, that's going to get you much more attention and would likely get more and more people to buy more of your products. But again, your answer is correct. Even if it doesn't, we can't make the idea that, this business is not profitable, therefore we need government violence. I don't see that as a valid point. We did get another question from Matt, which I shared with Stefan earlier. Daniel, if you could please share the screen so that we could put this question. It's at the bottom of the class notes. So if you could scroll, not this one. Okay, did you find it?
No, I'm not getting anything here.
Oh, I see. I didn't send you the file?
No, I don't see anything.
Essentially, the question is about a gaming company. Matt works for a gaming company, and they're trying to make a variant of an existing card game for the poker industry. They have a patent on this game and have tried to market it to many casinos, with only one casino having done a trial run, which was moderately successful. Some casinos showed interest, but none of them want to pay to run the game in their house, despite evidence from the trial run showing they will be more profitable for it. So our company knows that one of the online gaming sites would probably build their own version of the game if it was not patent protected by us. And since they already have the user base, money, and human capital to support and promote the new game. So essentially, they're worried that Matt works for a company and they're worried that they're having trouble selling their stuff, and they're worried that one of the casinos is just going to take the idea and run with it. If we allowed another company to make the game while we are still trying to get adoption or buy-in from casinos to run the game, the likelihood of this company becoming profitable would be slim to none, at least for the foreseeable future. So for this company, this takes most of their livelihood from one or two developing products that are still without user adoption. I'm not sure how else they remain relevant without a patent, given that many casinos... Oh, there it is. Yeah, if you could just scroll down a little bit, please. Yeah, so, yeah. Many casinos have seen the product but do not want to necessarily pay to play. In our case, we're not seeking patent trolling. We're not rent-seeking patent trolling or trying to slow innovation, but rather make sure we have first-mover advantage by being able to have casinos offer this as another game. The problem for the past few years is that the casino industry is horrifically slow to innovate, does not like change, and tries to pinch every penny when they are not laundering it. So this is Matt's question. What do we think of this? It says it's a tiny stake, but he never gave patent much thought, but he's beginning to think about it now. So what do you think, Stefan? Do you have some thoughts on this? And you're muted. 1 second, let me just unmute you.
All right, now
there you go.
Yep, sorry.
Yeah.
Not clear exactly what his question was. I just sent a link to the list. I have a book or a little pamphlet called Do Business Without Intellectual Property, which gives you ideas for ways you can try to minimize or avoid using IP when you don't have to in today's world, but it's really hard. The bottom line is we live in a world, this is why I'm a patent attorney, is because I still represent clients who need the help of patent lawyers because they need to at least understand the system and navigate it, if not acquire their own patents for defensive purposes, just like you need defense attorneys because we have a drug war, or just like we need oncologists because there's still cancer. Doesn't mean that we all are in favor of the system that makes our livelihoods necessary. Unfortunately, I think you're going to need, by and large, to be aware of IP law, copyright, and patent, especially in like a gaming space. If you have investors, they're going to want to know: do you have your patents taken care of? Do you have an IP system? How you do that is what you consult an IP attorney for, and it's just there's a strategy you have to go through. It's an unnecessary cost. It will slow you down, and it could hurt you too. So I don't know in general what the question was, but yeah, I think you need to be aware of the IP system, and you have to work around it. Again, I would minimize it as much as possible because it can distort what you do. Everyone can focus on what's patentable instead of what makes money. I would go for what makes money and what's a good idea, even if you can't patent it. And don't be lured by the promise of getting protection from the government to protect you, because in the end, unless you become a large company, patents will only give you a lifeline for a little while. So I would recommend look at my pamphlet, Do Business Without Intellectual Property.
Yeah, I think it's not very clear from Matt's question what the exact question is, but yeah, I agree with Stefan that there are ways of doing business that don't involve patents, and I think there is an element of just institutional habit, and just people not rocking the boat, and people thinking that you have to do things the way that everybody does them because that's just the way that things are done. But you don't. And so maybe the business model for you is to provide casinos with this stuff and make the advantage being in support and in being able to run this better than anybody else, so that even if they could copy it, even if they wanted to copy it, they would realize that it just makes more sense and we get a better product if we just hire the people who produced it. I think trying to ensure that you're providing value is a good way of ensuring that you get paid, rather than trying to hope for a monopoly grant. Okay, well, any questions? Anybody else? Anything else you guys would like to discuss? Somebody, I think, did we get any other questions that I skipped in the chat? I'm trying to remember. Yeah, Boris had mentioned a point which I think is also worth mentioning. There are so many ideas that come to you once we just start thinking about how a world without patents works, and this is one of them. And I think we've barely scratched the surface of why a world without patents would be so much better, because we start thinking about things like this. So for instance, Boris says companies can just invest in protecting their IP from leaking. So if you figured out a new industrial process, you don't have to tell the world. You don't have to get a patent. You don't have to tell the world. And then you just make sure that it stays in-house. Only a few engineers are allowed to know the process, and those engineers are made to sign acts that prevent them from disclosing this information to others. And you can keep a trade secret for many years and continue to produce from it. And maybe one aspect Boris mentions is that you won't be as willing to move manufacturing to China in this situation. Yep. And maybe that's not a bad thing. Of course, as free market economists, people generally think that you must be in favor of free trade. And of course, you're in favor of free trade happening, but that doesn't necessarily mean that we would get all of the trades that happen under what is viewed as free trade agreements today. We would get it in a free market. And so maybe you would still have more industrialization in Europe and the US if trade secrets mattered more, rather than people just relying on this extremely sophisticated political legal framework of trying to protect their knowledge and then trying to.
Let me mention one thing there too. Yeah. Another way that the patent system impedes the use of trade secrets is that, okay, in a free market, you keep a trade secret. Maybe eventually it will be leaked or reverse engineered, but so you might have trade secret protection for decades. The danger under a patent system is that if you keep it as a secret, if someone else independently invents this thing, say 10 years down the road, they could theoretically get a patent on it and then stop you from using something that you invented first, right? So that is one absurd, bizarre, unjust, unfair feature of the patent system. So under a patent system, there is an extra danger to keeping something a trade secret, and that is that someone else might patent it and keep you, and then get an injunction from a court and stop you from using it yourself. So because of the patent system, there's an extra disincentive to relying upon trade secret, which is what people would tend to do absent IP protection.
Can I ask a quick follow-up question? So obviously the companies can do more effort in protecting their trade secrets, for example, by not exporting some of the key manufacturing processes to countries such as China. But in this post IP protection world, how would we go about protecting trade secrets of employees who basically leave the company? So you're paying an employee to design certain processes, to design certain products, then they go to the competitor and basically take the trade secrets with them.
That's the whole. So the way you protect a trade secret is you have policies and procedures in place that in the company, and one of them is, part of that is the employment agreement, or which usually includes a non-disclosure agreement. So you basically have a private contract with employees and with anyone else that you contract with that has to have access to this information. Like you have to give them plans and specs to make a product. So you have a contract with them saying that if they leak this information, then they're subject to damages. So that's usually enough of a disincentive, except in the case of China, which is, I think, what Trump and these other guys, when they say China's stealing our trades, our IP, I don't think they mean patents or copyright. I don't think they know what they mean, actually. I don't think they care. But I think they're talking about China doesn't have a totally free market investment system, right? They control their economy. So if a foreign company wants to open a factory there, they can't just go do it. They don't have the right to do it. They have to get licenses or permission of the local government and maybe the national government or regional. And that license is usually conditioned upon you partnering up with a local company. Like it's sort of protectionism, or they're trying to protect local industry by saying, okay, if Apple, you want to have a factory making iPads in Wuhan, you need to have a joint venture with a local Chinese company so we can give jobs and get political credit for it. But once you do that, now it's not under Apple's control, and you have another company that's working with you, and they're going to inevitably get access to your proprietary secrets. And then they're going to leak it because that's a Chinese mentality, right? I think there's a book called Stealing Information is a Beautiful Thing or something like that. That's which I agree with. I think copying and learning information is a good thing. It's not a bad thing. That's called competition and learning in the free market and standing on the shoulders of giants. But the whole NDA process, non-disclosure agreement, this agreement has been corrupted because we rely upon patents which the Chinese don't respect as much as the West does, because they don't have as many industries twisting the arms of their legislature like we in the US do with Hollywood and with the pharmaceutical industry and the music industry. I think the bottom line is you have a non-disclosure agreement, a contract with your employees, and that will help you bottle it up for a while.
Yeah, and you pay them well enough and you incentivize them to stick around. You make it so that if you stick around for another 5 years or 10 years, and at the end of the 10 years, you don't leak anything, then you get a massive bonus, for instance. I think that's sticks and carrots can contractually take care of that without having to resort to the threat of violence. I think it's impossible to come up with a solution in which, in my mind, I keep finding that this thing is bad, and therefore the only way we can fix it is to just allow people to use violence to force people to fix it. I think that just always, if Austrian economics taught me anything, is that this always backfires. Andrew, you wanted to ask a question?
Yeah, I have interested. Hello, can you hear me?
Yes, sorry, I muted by mistake, but go ahead.
Yeah, I'm particularly interested on what your thoughts on this so far. It occurs to me that the complete lack of intellectual property is something which is very powerful about Ethereum, your favorite thing in the world, with respect to the fact that anyone is free to create an application. And when they deploy it on the Ethereum blockchain, the code is visible, which allows anyone else to just build on it without asking permission. Is completely, and it creates this unbelievable force for innovation where you have people building on something else, and then someone comes out and builds on what you're building, just like you're talking about. And you have this now concept in Ethereum of money Legos, where someone builds an application and you have this little building block and someone else can build it. And I'm interested to hear what you think about that, considering that Ethereum is, of course, a shitcoin.
Yeah.
Yet it would appear to be a wonderful case study of the innovation that happens if you remove all intellectual property.
I will definitely say Ethereum has by far the most innovative Ponzi scheme in history. They put the Charles Ponzi's and the Bernie Madoffs to shame. These people working with their manual Ponzi schemes, filling out paper. This is another level of things, of operation. I think when we say the word innovation, for me, the key thing is that it has to be, for it to be an innovation, it has to be useful to people in some way or the other. And so far, everything that the Ethereum network is piling on is just a bunch of Rube Goldberg machines that haven't generated a dime of revenue for anybody. So honestly, my explanation for what Ethereum are doing, if you look at the last 5 years, is just an endless number of new ideas that come up that we're going to build this on top. We're going to do this. Okay, why do you need this? Because we're then going to build on it. We're going to build X on top of it. Okay. You wait, and a lot of money is raised for X, and then X never does anything. But then, oh, don't worry, we're going to build Z on top of X, and then Z will change everything. And then we'll build Y on top of Z, and then we'll build A, and then B and C. And it's just an endless kicking of the can of new things that are being developed. It sounds impressive if you look at it, if you think that actual productive things are being built. But I think the actual reality of what's going on here is that the smart contract is a mechanism for tying people's money into the Ponzi. And so the people who bought in at Ethereum early, they could buy into the pre-sale, for instance, and then they couldn't sell the money because of the smart contract functionality. So they could only keep it and put it and invest it in other things. So that creates a massive incentive for people to take their Ethereum tokens and invest them in some kind of second layer solution, produce a new token, pump that new token, get a new bunch of people to hold the token. And then once you've done that, then there's an incentive to build something else on top of it, get a new bunch of engineers to promote a new bunch of buzzwords, get a whole new bunch of people to come and invest in it. So in a sense, I think maybe the most damning critique I have of Ethereum is the idea that if you think that Ethereum has developers, then you also think that Herbalife has chemists. In reality, Herbalife and Ethereum, they just have bag holders. And so you've got random housewives in the US who think of themselves as chemists and entrepreneurs, but really they're just buying large amounts of Herbalife products and signing up for an obligation to sell more of this to other people. And that's effectively what you do if you launch an ERC token on Ethereum. You have to buy up a lot of Ethereum and tie it up in your contract, and that just generates more demand for Ethereum. So I think that's really the innovation here. And yes, removing intellectual property has allowed the Ponzi industry to prosper and innovate in this regard.
Let me just say one thing. What's funny is Safe is like the bizarro universe version of me, because every time I talk about anything, IP always comes up. And I can see that for Safe, even when IP comes up, coin will come up.
Oh, shit coins.
Okay, true.
Yeah. Boris, you wrote something. I try to protect trade secrets with NDA with employees. Would that not contradict the Austrian theory of knowledge and information not being scarce? After all, why would it matter how the knowledge and information was acquired? I don't think that the Austrian theory necessarily says, or the theory of knowledge says that information itself is not scarce, but the access to the information can be made scarce. You can keep a secret. You can prevent people from finding out a secret. And if you find that this is beneficial for you, then obviously there's nothing wrong with people keeping information for themselves. I don't see why it would be wrong. I think obviously, I don't think Austrians or Stefan would say that they're against people keeping secrets, that they're against people keeping things to themselves. Going back to the metaphor of the safe, of the money from the safe, there's nothing wrong with keeping your money in the safe. There's something wrong with throwing it out of the window and expecting people to bring it back to you. And I think it's the same thing. And there's nothing wrong with keeping a secret. What's wrong is telling people the secret and then expecting them to behave in a certain way about it. So I'm going to tell you this thing, but I need to control your body and punish you if your lips ever say it again. That's what I think it's legitimate.
And let me add, the only thing I would say that Austrian or libertarian theory has to add is, so there's nothing wrong with using contracts and enforceable agreements, but you have to understand that intellectual property, most people make the false argument that, like I said, that it's fraud or it's a contract breach or something if you don't respect it. And they're assuming that you could build a case for IP on contracts, which you cannot. It's too complicated to get into here. But property rights are what we call in rem, or rights that are rights against the world. Rights are called the law between the parties, or in personam. It only means what affects two people that are parties to a contract. And you could never get in rem rights generated from contract rights. You just can't. That's one mistake Rothbard makes. But my other point is, contracts have to be understood, as Rothbard explained, as just the exercise of ownership over an alienable resource by the owner. That's what a contract is. So we have to understand contracts in the Rothbardian reformulation sense as being basically conditional, specified, alienable titles to property, instead of being binding promises. So if you have an NDA with someone, you could basically say the employee has agreed to pay a certain amount of monetary damages if they take certain actions after they leave the employment, or even during their employment, if they reveal certain proprietary information. So basically, an action like revealing information would be a trigger towards a transfer of property, like their bank account, $1 million in their bank account would transfer to the company. right? And now they could file a lawsuit to effectuate it and to get it back. But basically, the contract should be viewed as a transfer of title to property. And in this case, it would be damages. We call it damages, but it would really just be a monetary payment by the employee. And you would make it high enough to dissuade him or disincentivize him from reaching the agreement, but not so high that you would make them afraid to work for you. If I ask for $1 billion from you, then you might say, look, I don't know what you're going to accuse me of later. I'm not going to risk $1 billion of liability or even $1 million. So there's a balancing act, there's a bargaining position, and there'd be an equilibrium reached, and it would be reasonable fees would be agreed upon. Which is why I think, by the way, you could never have contract like with Amazon in a copyright-free world give rise to something like copyright, because Amazon could, at the behest of the publisher, insist that every customer who buys or downloads a Kindle for $5 sign a contract saying that if I copy this book or use this book, I owe, $1 million to the publisher in damages? If I want to buy a $5 book and I'm willing to be one of the few people that's actually paying this publisher and Amazon for the book, I'm not going to be on the hook for $1 million of damages just because I use the information that I learned. So I might say, I'll agree to pay $1,000, but not $1 million. Okay, so if all your customers are agreeing to pay a low amount of damages, then one of them is going to breach the agree. They're going to upload the file and just pay the $1,000, and then the file is out there public so then it won't have any effect. So this is why contract as a scheme could never result in anything in a private contractual sense that mimics copyright, because either the fee is high and dissuades people from copying it, in which case you lose all your customers because it's bad customer relations, or you have a low fee, in which case it doesn't dissuade copying. So there's really no way to build anything like copyright on some kind of private contractual scheme. But if you could, I'd be in favor of it. I just don't think it's feasible.
The closest we could have is industrial areas or trade areas or common guilds could establish some kind of
yes. However, so the only problem with that argument is that antitrust law now prohibits that kind of stuff, because then you'd be accused of a cartel or monopolizing or collusion. So again, it's another case of a government regulation, namely the antitrust law, that prevents private solutions that would get around some of the private market failures of the difficulty in protecting business models that rely upon information. So yes, I agree. Contracts should be free, antitrust law should be abolished, and people should be able to have these guilds which try to protect in some way among doctors or comedians or magicians is one example. You can have these guilds where they all agree, and magicians are pretty good about that. But theoretically, a lot of these guys are skirting the line of violating antitrust law. So again, we have another case of government intervention that makes private solutions to these problems difficult, and then the government steps in as a white knight with patent law and copyright law to solve the problems that the government regulations have helped cause.
Yeah, I think the way that I think of it is that in a free market system, if there was some benefit to something like this, you could see say along the supply chain, the competitors would all agree. There'd be a guild of, say, people in the production of, let's say, cars, for instance, that whether it's the people who supply the cars with the raw material to supply the car factory with the raw materials, and the engineers and everybody involved in the process of the production of cars, they may be in a completely free market. In a place like Detroit, which is the center of car production and the center of all these derivative industries related to cars, everything from the rubber producers to the car rentals to everything that is related to it. If there was such an advantage from having copyright laws, you could see something like this happen, where all of these sign agreements with one another, and then according to some rules, where if Ford introduces this kind of design to a car, then we don't accept that anybody copies that. And then if Chrysler copies that, for instance, then the consequence will be that everybody will shun Chrysler, and then Chrysler is in trouble and it has problems with its own financing. It sounds a little bit contrived, and I'm not exactly entirely convinced of it, but I present this as the sort of thing that were this actually to be the case, that we had a problem in, say, in the car industry, that we don't have innovation because everybody's just continuing to copy. Then the world in which we find a way around this copying is going to be more productive than the world in which we don't. And so a place like Detroit that would employ some kind of guild system for the car producers like this, where everybody agrees to respect everybody else and anybody who steps out of line is shunned by everybody else. Maybe in that situation, we'd see Detroit, for instance, outcompete European car makers or Japanese car makers, and this model would be more and more successful because they all protect each other's intellectual property and so on. So we could see how this could happen, and we could see how also it could even involve consumers. Consumers would want to even boycott those who engage in this kind of anti-guild copying. Having said that, I'm still not entirely convinced. I think information wants to be free, and I think there's always value to be made. You can always make value from doing things with knowledge, and people will always just be able to find ways of making money without having to resort to extremely sophisticated ways of maintaining knowledge closed up.
Safe, look what happens when a coin is open source and competitors pop up and they try to copy Bitcoin. Look what happens to them.
Yeah, exactly. It's a good idea, actually. Yeah, we've had a lot of arguments about how all of these copycats with Bitcoin, but here we are. Bitcoin's dominance now is more than 2/3, which is astonishing if you think about it, because the cost of adding the 1/3, which is all of the other coins of the total market cap, the cost of adding an extra dollar onto that amount is much lower than the cost of adding an extra dollar to Bitcoin. Like if I wanted to raise the market cap of Bitcoin right now, I need to buy more Bitcoin and hold on to it. There's no other way. But if I wanted to raise the market cap of shitcoins combined, with a few $1,000s, I could make millions of dollars of shitcoin market cap. So I just need a press release and get listed on an exchange and start wash trading between myself and my computer. And we generate enough volume to have a $50 million coin added. Obviously, with time, it becomes harder to maintain that volume because people will buy and sell and the price will come crashing down. But it's pretty straightforward to add it, at least at the beginning. So we've had 5, 6, 7 years of every day new shitcoins are being produced, new market value is being added. But even after all these thousands of coins were produced, without any kind of copyright and without Satoshi going around threatening people, we see them losing liquidity, losing volume, and heading towards the complete insignificance. And I think you just need to wait a little bit and the universe will take care of it.
I've got to go just a second, say if I have an appointment I have to make.
Yes,
so just a second,
yeah,
I've got to run.
I think we're going to be wrapping up. Thank you so much, Stefan. And anybody else have anything else you want to discuss? Stefan, feel free to leave at any point. We've been here for 2 hours, so I think that's probably enough. This has been the longest of the discussions. Thank you very much. I really enjoyed it a lot.
Thank you, guys. I enjoyed it too. Good luck with the course. Thank you, everybody. Feel free to email me offline if you have any questions. Bye-bye.
Yes, and find them on Twitter too.
All right, bye-bye.
Okay, bye-bye.